the issue that you're running with real estate is you're working with two separate bodies of law. You're working with probate law, and you're working with real estate law. And you can sell the house at any time, but you can't transfer title without the authority. And so, like, it's just gonna sit in escrow anyways because the title company can't issue a clean deed because you don't have the authority from the court yet. And so that's the problem that people run into. And in Utah, the trigger for probate is any real estate and or cumulative of 100,000 or more.
Okay. Hey guys, welcome back to the Probate House Guy podcast. I'm Brad Woodall, the Probate House Guy. Appreciate you joining us for another episode here. Today, we are continuing our series on getting a probate attorney from all 50 states to discuss their specific state. And today, I've actually got an attorney, Michael Glassford, who is an attorney in two different states, in Missouri and Utah. So, Mike, why don't you introduce yourself?
Well, thanks for having me on. And like you said, I started my practice in Missouri, then I went to Utah, and now I kind of straddle both states. My main firm is in Utah, but I invested in some property in Missouri, so we spend time both places. I've been an estate planning attorney for going on my 20th year. Now, obviously, when you start law, you don't just specialize right away. So I've done divorce work and criminal defense work and traffic tickets, and I've been a local prosecutor and then been on drug court board. So I've done a lot of my career, but my interest has always been estate planning because I'm a storyteller. I write books, and what better area of law to focus in helping you create your own story? Because one of the biggest narratives out there is that estate planning is about death. Like, unless you're a Viking or a Klingon and you want to die well, like, I want to live well. How about that? So, like, maybe, just maybe, estate planning could help all of those living days just as much, if not more, than that one death day, which we'll be ready for.
Sure. Yeah, getting prepared for that. But you know what? The reality, you know this, and I know this, the reality is the vast majority of Americans do not do any estate planning whatsoever.
No, it's a high percentage, like 60, 70%. Until we get into our 70s and 80s, then the number shoots up to like 80% having an estate plan.
Right. Yeah, definitely. I know, as I became an entrepreneur and started growing businesses and stuff like that, I really had to start thinking about that, and once I had kids, so I've, done some estate planning for myself and put some contingencies in place with my companies. So if I die, my wife kind of knows what to do. Really, she knows. I've actually put one of my attorney friends in charge and said, call him when I die and he will be your advisor, and he knows that he's going to be the advisor, right? Like, because she doesn't know how to run all these businesses, right? But this is what you do if I die. These are the steps you need to take. This is how you divest these assets, like, boom, But most people don't do that, and their families are left with a mess to try to figure out, for sure.
Yeah. I kind of equate it to dining and dashing. Like, nobody will ever do that. No one will ever confess to doing that. But, the general concept is you go into a restaurant, you have a nice meal, and you take off. Usually teenagers do this.
Yeah.
And then the waitress has to fit the bill, like, that comes out of their pocket. But that's what we're doing to our kids if we don't have something in place. We had a good life, and we're like, all right, we're out, and you all can pay for this. You like our stuff. If you want that stuff, then you got to pay more for it to get it. So we've really just dined and dashed on our kids.
Yeah, that's a great analogy. I've never heard that one before. I love that. That's great. Well, hey, it's good talking to a storyteller, too. You probably have a lot of good analogies for these things, huh?
Oh, yeah, it's fun.
That's cool, man. So, like, you mentioned that you always kind of had a thing for estate law, and you've done a lot of different things. Like, was there, like, one thing that made you decide, like, hey, I want to focus in this space? Or was that a process to kind of transition into that?
It was actually something that happened at the tail end of my law school. Like, I was biting at the bit to get out. So my last semester, I was actually not at law school. I was living where I was going to be working and externing and interning and going back to law school one day a week for the credit hours to make me an official law student to finish up. And we had just left Home Depot because we were buying our first washer and dryer. So excited. We actually didn't take it home with us because I was driving a little Pontiac and driving home. And this was in Missouri. and one of those microburst storms happened, like
Mm-hmm.
just like cats and dogs on top of you, but if you stick your arm out the window, that's like dry, like it's just like concentrated.
Yep.
And there were two semis in front of me, one to my right and two behind me. We were completely boxed in on I-70 going east. And my last memory was like, oh, this isn't good. There's probably a swear word in there.
Mm-hmm.
And we hydroplaned. We spun across the median and crashed into cars coming westbound. And I just had this enormous accident. And you know, jaws of life was used to get us out. My wife and my son was in the car. And miracles upon miracles. That's another story for another day. But it just hit me like a ton of bricks that we weren't ready for that.
Yeah.
You know, had we died, there was no plan in place for my son. There's just nothing, and it really set the tone for my career. Like, hey, I don't want that to happen to anybody else. We were lucky, we were fortunate, but a lot of people aren't.
Yeah. Wow. That's a crazy story for sure. Yeah. Life's not guaranteed to us. And you've got to kind of A, live life to the fullest for one thing, and then B, prepare for things for sure. So, what would you say are the biggest mistakes that people make with their estates, like in general? You've seen the gamut, right? So,
I think the biggest mistake is we buy into the narrative. There's three things. There's more, but I round it down to three, and we think that estate planning is for rich people, not for us. We think that estate planning is for someone older than me, not me. And we think that estate planning is too expensive and it's not worth it. And, on that last point, it's just the attorney's fault, and I can't speak to them because we're jerks, we're horrible, we're awful. But, the other two, I tell a really stupid story to kind of get us over that hurdle. And the crowd that I speak to, they know who Mr. Bean is. He's an actor. He's kind of weird, Rowan Atkinson. And I say Mr. Bean won an all-inclusive trip, and I'm centered in Utah, so he wins an all-inclusive trip to Las Vegas, including a car because he was like number caller 9 on the radio. And he's so excited that he runs to Las Vegas and he buys the car on the Strip. I use Mr. Bean because he would do something like this, and people are like, Michael, that's the dumbest story I've ever heard. I'm like, I know, but that's how you approach estate planning. You think you need to arrive in Richtown before you get the vehicle that was designed to get you there.
right.
It's a mindset shift. Not for the rich. It's for you now. It's how you build, acquire, attain, protect, preserve wealth, and stay there and keep your kids there. So a little bit of a, don't buy into the narrative. And then, we don't want to think about our mortality. We already kind of touched on this. Don't think about living. Think about writing your best story, because having that system in place will protect you now, give you more courage now to do that risk, to jump out of that airplane, to bungee jump, whatever your passion is. Those things are in place. Just even a trip to Europe because your kids are safe.
Yeah, for sure. And the reality is like with the car analogy too, is you buy more than one car in your life. So over time, your estate plan will change. As you get older, you might add things to it and bolt on new parts. And, so you're not going to do it one time when you're 30 and like never do it again. Like you might change that through life. So just understand that too, right?
No, that's fantastic. No one's driving their 1970 Gremlin anymore.
Right. Yeah. They're like relics now, right?
Worked at the time, but yeah, not so much. And
Yeah.
that car analogy works great in so many aspects of my profession, because another downfall is people come to an attorney and say, how much is a trust? And I'm like, well, that's like walking onto a car dealership and saying, how much is car? And the salesperson's like, wait, like what car? Like a sports car, a truck, a sedan? Like, I need to know a little bit more about you and what you want to use it for before I can put you in the right car. And that's why I do 20-minute consultations, for free, because we need to have that conversation before I can tell you, what the project is going to cost, because I don't know your needs yet. I don't know what you want to achieve. And there's a danger in that. You're actually setting yourself up as on the downside in the negotiation, because when you say, how much is trust? If the attorney is dishonest, they're going to say top dollar. Oh,
right.
It's $10,000. Let's do this. And you're going to say, okay, That's
Yep.
also a problem.
We get people that call us that want to sell their house, and they're like, "How much will you give me for my house?" I'm like, "What's your name? What's the address of the house? How big is it? What condition is it in? Like, I don't know. you know, let's get some more information." So you're doing the same thing, right? Would you say it's probably the best tip for people to make that process go smoother is do your consultation?
Yeah, just do the consultation. Like people are afraid of, the obligation. Like, well, they're kicking the tires. I get it. I do it too.
Sure.
But when you're talking to the attorney, be upfront. I don't know about you. I want to have this 20 minutes, not to pay you money at the end, but to pay you my time with another appointment if I like you. Just be straight.
Sure. For sure. Yeah. Tell them, hey, you know what? I think I'm going to go with this guy over here because of XYZ. Or I really liked your presentation. I'm going to go with you, right? No harm, no foul, right?
Yeah. No, there's so many quality attorneys out there. I shouldn't say you can't go wrong, but do your due diligence, talk with the attorneys. When you're speaking with the attorneys, it's almost just as much about their personality as it is the level of law they know, because and this was more of a rule when I was doing divorce work, but if I thought that I couldn't laugh or cry with my client, I wouldn't accept the case.
That's a great analogy.
And it's the same. Like, if it's going to be pulling teeth to work with any attorney in any level, don't hire them.
Yep. I do the same thing when I hire employees, right? I focus way more on an employee's personality profile and their traits on how well they get along with the team than what their resume says they have experience in. Because at the end of the day, that matters more, is how you guys can mesh together. Because if you're butting heads, you're never going to get anything done,
Mm-hmm.
For sure.
And and this matters to everybody. Like, in 20 years of practice, I've been asked, like, maybe twice, like, what was your GPA in law school, and
Right.
how many times did you pass the bar, or take to pass the bar?
Yeah.
I don't even remember my GPA. I know it was like a B average, and it took me one time to pass the bar. But
Sure.
no one ever asked that. They just they talk with you. They like your personality. They feel comfortable with what you're doing, and you go to work.
Exactly. And I mean, being an attorney, right, that because you had to pass the bar, you have a minimum level of legal understanding you have to legally pass.
Which, hopefully, that's a thing. But now, no knock to the system, but now they have attorneys practicing, not attorneys. They're paralegals. In Utah, you can have a paralegal degree and be writing LLCs. You can be preparing divorces. They just can't go to court. So again,
Right.
maybe you should ask, what level of licensure do you have? But
Sure. Yeah.
Beyond that, you do need to feel comfortable with who you're working with.
That's a good point. That's a good point for sure. So because you're uniquely kind of in two different states, right? And it sounds to me like there are probably some differences between the states. Versus Utah versus Missouri, like if someone doesn't do their estate planning, or whether they do or not, and they have to go through probate, how long does that typically take? Like,
and it depends on the case. Thank you, COVID. Everything takes longer now.
oh my gosh, don't get me started.
Right? It's just delay, and it should be faster because everything's like a Zoom appearance now.
Yeah.
Or whatever system the court uses. But it doesn't. It's not. And one of the reasons for probate is we have to have a certain amount of time in publication, and then giving time for people to file their claims against the estate. In Utah, when we publish, you don't actually have to publish, but when we do, we limit the time to 3 months. So
Okay.
I have a case a few years ago, and we published, it was in the paper, the prescribed amount of times, and then the 3 months elapsed, and then a hospital filed a claim, and I got to write the letter to the hospital saying, well, you're out of time.
Right.
You can fight this all day long, but we go to court, the judge is going to say, sorry, snooze, you lose. You're done.
Yeah.
And so that is the reason to publish, because we cut down the time for creditors to come in and make claims. If you don't publish in Utah, it's a year that they can make claims.
Okay.
So that will determine the time in court.
Yeah.
and it's just going to depend. So every claim is a new litigation that we have to legitimize. We have to figure out if it's a real debt, and then negotiate and figure out how we're going to take care of it. So that adds time as well.
Okay. So let's say you had an easy case, right? There's easy ones and there's medium and there's hard. Like, what would you say timeline is? Not a high, medium, low. Like,
so the easy ones are taking 6 to 18 months.
6 to 18. Wow.
The harder ones just add water. It's just going to be longer.
Sure. Wow, that's quite a long time. Now, also, some people think of, obviously you're an attorney, you see the probate process from start to finish, from petition to, closing the estate, right? A lot of people that are, inheriting a property or whatever, they think of probate only from the timeline of petition to when can I sell mom's house and get money in my bank account, right?
Mm-hmm.
But the reality is there's still more to it after that. So what is that typically like in Utah?
So the probate process, we have to file the petition, we have to get the personal representative appointed, we have to get past any objections from other parties that want to be considered. But once we have that personal representative appointed and they've accepted the appointment and letters have been issued, now they're the person, they're in charge. We can get an EIN for the estate, a tax number, we can open a bank account, and at that point we can sell the house, and we're in a position to sell the house with authority to make that transfer. So, but even then, if we sell the house, the monies need to go into the estate. That can't be distributed. All of the expenses can be paid out, but
right.
The heirs are not going to get that money until the estate closes.
And that's generally based on the creditor's period. Once that period kind of closes out,
creditor's period closes out, and everything else, and then we would need to do an accounting, and sometimes it's the paperwork, and sometimes it takes the family a long time to get that together. For me, I can't do anything until I have the numbers, and so again, you're looking at 6 year, 18 months.
Okay. And in Missouri, is it similar, better, worse? Like, what's over in Missouri? Is it?
I would say it's similar. I don't do a whole lot of court in Missouri.
Okay.
I focus on the transactional side and keeping people out of court.
Sure.
But Missouri is percentage based to go into probate. So just rough numbers. If your estate's 600,000 ish, you had a big farm. It could cost several $1,000s to just file the probate. Utah, it's a flat filing fee. So every state's different there.
Sure.
Every state's rules on how much you have to publish. In Utah, it's 3 weeks consecutive in a local paper.
Yep.
And then what the timeline is after that, it's 3 months in Utah before the cutoff.
Okay. Yeah, in Georgia, where I live, it's 5 weeks. You have to publish for 5 weeks, every week for 5 weeks. And then after that, they can take the money out of the estate after that if they've sold it. So it sounds like, and every state's different. That's why we're doing this. Why we get an attorney from every state, because everybody's different. Every situation's different. Everything's different. And we always recommend to everyone talk to a competent estate attorney to help advise you on your situation and your state, so you can make the right situation. Don't just read everything you read on the internet. So, cost-wise, you mentioned in Missouri it's a percentage of the estate. In Utah, you said there's a flat court filing fee. In terms of like attorney's fees, do you guys kind of do a retainer? Do you have? Is it like how does that fee structure typically work in Utah from that perspective?
Oh, it's a retainer. It's I love vehicle analogies. It's like putting gas in a car.
Right.
I put 20 gallons of gas in my car. I'm not going to burn all 20 gallons today, but that's going to keep me moving. And the client needs to think of it this way, because, if the 20 gallons is gone, the case stops. The attorney's not moving. And
Sure.
So it's going to be between you and your attorney. They're usually going to want a minimum retainer, because they know that's going to take at least that much gas to get things rolling and have initial hearings and filings and interviews. But beyond that, I always said, look, work with your attorney, and if you don't want to drop 10 grand, then say, hey, I'll be in your office every Friday to pay $800.
Hmm.
And you just show up and you just deposit the $800, and two things happen there. One, you're not putting it all up front, but two, the attorney's seeing you every Friday, and guess what? You're top of mind on their case agenda, and they're working on you.
Bingo.
So if they don't see you for 3 months, sometimes it's easy for them to not think about your case as much. I mean, we have our own systems and whatnot, but it's just a little tip to keep top of mind with the attorney.
That's great. The squeaky wheel gets the grease, right? I mean, we tell people that all the time. The quicker you can get your stuff to the attorney and the better you communicate with that attorney, the faster your case will probably get done, right? Because we're all busy. And, you just gotta think in those terms. So
Absolutely.
if someone can't afford probate, which we deal with this a lot, right? Some people that maybe, don't have a lot of money, they need to sell mom's estate or whatever. Are there ways that they can alleviate that cost a little bit, or kind of maybe pay later after the fact, like maybe a lien secured against the estate or something? Can you do that in Utah or Missouri? Is that a thing?
So typically not interested in that. Whether you can or not, it's just additional time, and
Mhm.
it's going to be even more expensive to do something like that
Yeah.
to have that secured credit. But there's so many ways. I mean, number one, just talk with the attorney. Maybe they have a plan. Maybe they take Visa, MasterCard, American Express. Maybe there's so many like SaaS programs out there that you can that do third party lending, and there's a lot of ways. I mean, I just talked with someone the other day that she buys houses, kind of like you, and
Mhm.
she's like, I'll pay for their probate.
Oh, yeah.
I'll pay the money if I can have a contract to buy the house.
Yep.
And so they work things out that way. Lots of just don't. The worst thing to do is to think that there is no option and not to talk to an attorney.
Absolutely.
The attorney sees it all the time, and they're like, "Oh, you could talk to this person, or we could have this option, or we can figure something out."
Definitely. Yeah. Yeah. We do the same thing. I've paid for many people's probates, kind of advance the money, and just agreed to get paid on the backside. Now, I have gotten burned by that before. I've had people that did that and then went behind my back and sold it to someone else, and I've lost thousands of dollars. And that's a risk that comes along with it. Not everyone in this world is honest, unfortunately, but it happens. But yeah, I mean, there are ways to get your probate done. Like, don't think, because so many people just bury their head in the sand and they don't do it. We've had families come to us that want to sell an estate, and it's like 3 generations that they haven't probated, and now it costs more money and time and effort to get this done. So don't bury your head in the sand. Get it done for sure.
Mhm.
So in Utah, are there ways for heirs to like sell a house outside of probate, or that some states have kind of exceptions, like there's like affidavits of heirship, that sort of thing. We have something similar in Georgia called an affidavit of descent, and there's some guidelines behind that. Does Utah have something similar like that? If they, if they only have a house, they don't have anything else in the estate, is there?
So not really. The issue that you're running with real estate is you're working with two separate bodies of law. You're working with probate law,
Mhm.
excuse me, and you're working with real estate law. And you can sell the house at any time, but you can't transfer title without the authority. And so, like, it's just gonna sit in escrow anyways, because the title company can't issue a clean deed because you don't have the authority from the court yet. And so that's the problem that people run into. And in Utah, the trigger for probate is any real estate and or cumulative of 100,000 or more
Okay.
property. So,
Okay.
if we're under that, if it's just a car, yeah, we can file a small estate affidavit and get the car transferred and get, things that way taken
Okay.
care of. But we do, it's an authority question rather than an ownership question.
I gotcha. Yeah, and a lot of states do have the small estates. I had last week, I had some attorneys from Arizona on. They have something similar, and I think in Arizona too, it's also 100,000, right? The cumulative value of all the assets can't exceed 100,000, and if they do, then you've got to do the full blown probate, right? So,
But if you have a shack with a deed, then that's going to trigger a probate.
right. So any real estate triggers probate.
the state.
In Utah. Okay. Wow. Even if you own this like little piece of a little sliver. Yeah. Wow.
And that, that's a downfall too, because sometimes it's not worth probating, but
Yeah.
you're not going to be able to get rid of it without, you can like maybe have someone live there for 20 years and claim adverse possession. I don't know, but it's not a quick fix if you don't do it right.
We do a little bit of tax deed, tax lien kind of stuff, and I've seen these little slivers of land that you'll see come back through the auctions again, where some sucker buys it at the auction and then realizes they got this like tiny little worthless sliver of land because they didn't do their research, and then they just quit paying the taxes on it, and then it goes back again, and then you just see this piece of land pop up over and over again. It's like you think at some point the state would just be like, let's just make a park out of it or something, Like, so, now in Utah, obviously it's not recommended, but can someone do probate themselves in the state of Utah, or do you have to have an attorney? Some states require attorneys, some states don't. How's that work in Utah?
Pro se litigation is acceptable in Utah. The old adage, when you have the same attorney as a client, you have a bad client or a horrible attorney, because you're too close to it. That's the first thing you need to be thinking about, like how emotionally attached am I to this, and you probably shouldn't be representing yourself, but you have every right to do that. I can go and watch a bunch of YouTube channels and figure out how to dismantle my engine and clean out my carburetor. I can eventually do that. There's some risks to that because I'm probably going to mess it up and not put it back right and blow up. But I can, and it's the same with probate. You can do it yourself. There's the state of Utah has a bunch of guides you can download. You can all the forms are online there. But there's a trick to that, and I kind of feel it's a little bit nefarious. I think that when states do that, they're not necessarily supporting the public. I think they're supporting the bar, because I think that people are going to mess up, that they're going to have to go to attorneys, and it's going to be more costly to fix their mistakes than if they had just gone to an attorney in the first place. But that's my cynical view.
Hey, you're not cynical. That's literally what every single attorney I've ever talked to says. The same thing is, it's going to cost you more money to fix it on the backside, just like the car analogy, right? You work on your car yourself and you mess something up. And like, I'm a car guy. I in college, me and my buddies were swapping engines into cars that didn't belong in those cars. And there were a few times where I had to walk to the dealership with my tail between my legs because I messed something up and I didn't have the right tool to reprogram that computer or whatever. And I had to go pay money to the dealer to fix that one thing that I wasn't capable of doing. It was beyond my scope, right? And, the state law is the same way, right?
At that point, you probably paid more than what the service would have been in the first place.
Probably. So, yeah, definitely. So, are there any, we already talked about this, like shortcuts. You mentioned small estate affidavits and a car. If someone wanted to do that, like, is that a pretty quick process for a small estate compared to a regular probate in Utah?
Yeah, if they're eligible for it, it's literally making the affidavit and then using that affidavit for the transfer of the vehicle.
Okay, well, that's pretty quick there. Okay, and we mentioned notice to creditors period already. If an estate is insolvent in Utah, we've dealt with this sometimes where people will be like, "Hey, I know Dad owed the IRS a bunch of money or owed American Express a bunch of money or whatever." Are there any reasons in Utah where someone might still want to consider filing a probate and going through that process if they know ahead of time that it's going to be insolvent?
I mean, every case is fact specific. We're going to sit down and we're going to look at, what the obligations are, what the debt is, what the creditor is interested in.
Mm-hmm.
They're not interested in your mom's stuff. If there's a value there and you can sell the stuff, or you can put a value down for it so you can keep the stuff and they get the value of it. There's always someone on the other side of the phone that's willing to talk, that's willing to negotiate, that's willing to, sometimes they're just playing hardball and they're like, we want everything. In that case, just walk away. Say, all right, you file the probate. Uh, but it's just gonna depend. It's gonna be, fact by fact, case by case, and we need to account for the emotion that's involved. Like what's the attachment to this thing? Like if
Sure.
it's mom's house,
Yep.
and we just can't part with mom's house, and okay, go get a mortgage and
And
buy it out and pay off the lien, or whoever is thinking that they're owed money.
Yeah, many people don't realize they can do that. I've helped a guy do that a few months ago, where he had inherited the house from grandpa, and like he really wanted the house, but he couldn't afford to pay this. It's like, we'll just go get a mortgage and just buy the house from the estate. He's like, oh yeah. So it's like, here, call my mortgage guy. He'll get you hooked up with a mortgage. You'll just be the buyer, and the estate will be the seller, and you have to get an appraisal. You'll have to present that to the court and say, hey, this is what the house is worth, and I'm going to buy it from the estate. And it's like, oh, wow, I didn't even know that. It's like,
and the I don't know, the thing to remember is that the third party waiting to collect, they're not a party to that action. So if the estate sells it to you at a reasonable price, but maybe not at full market value, like the creditor is going to have to accept with what the estate has, not necessarily what you bought it for.
Right. Yep. Definitely. So, obviously you do a lot of estate planning, and in that you're doing a lot of wills for people. Are in some states, holographic will or handwritten will is valid, and some they're not. In Utah or Missouri, can you have a handwritten will? Is there certain guidelines around how they have to be executed?
So there's specific rules in both states. Utah, you can have them. I never recommend them because estate planning is twofold. The first part of it is doing it right and having the legal authority to, imbued in a document, a will or a trust or whatever the case may be. The second part of that is managing expectations. Like, you can have this beautiful document, but if nobody knows about it and it comes out like day after you die, and it's shocking, it's a shocking revelation of who you've given things to, they're going to fight over it. They're still, even if there's clauses, they're still going to fight over it because you didn't manage the expectation. And so a lot of times holographic wills fall into that category because you wrote it, you didn't think about it, you put it in a drawer, and now not only are they going to fight about it, but they're probably going to be successful in their fight because you didn't do something right in the holographic will, or you contradicted yourself, or you didn't sign it right, or you didn't have it notarized. There's lots of chinks in the armor on that because you just wrote something.
Yeah, we see that happen a lot, where we'll get people that come to us, want to sell a property, and they're like, well, my dad had a will, and then they present the will, and it's like, well, your dad wrote this on like notebook paper, and he didn't get it executed and notarized properly. So like, who's to say that you didn't write this will last week? And like, we all get good at writing our parents' handwriting, right? Wink, wink, nudge, nudge when we're kids, right? Who's to say that you didn't just write that,
I was excellent at signing myself out under my mother's name with her consent. She's like, you're getting straight A's. If you need to sign yourself out, do it.
There you go. Mine was my mom and dad would like go on date nights on the weekend, and they'd give me their checkbook, and we'd order pizza on a Friday night or whatever. And my mom's like, just sign my signature on the check or whatever. And got pretty good at signing her signature. She gave me permission, right? It's not like I was writing checks otherwise, but yeah.
It's not forgery if you have consent.
There you go. Bingo. The attorney giving the great piece of legal advice right there.
For teenagers to get away with stuff. No.
That's right. That's right. So in that same tone, right, with the wills, are there common things that you see that might invalidate a will, like in Utah?
So the first thing to consider with a will is, we watch a lot of movies and TV shows, and it's in the narrative. We know we need a will, and we think that if we have a will, that everything will be taken care of. But the purpose of the will is to tell the judge what to do with your property when you die. So what's wrong with that paragraph? that there's a judge involved at all. So a will, while being proactive and kind of taking the horns of court, so to speak, you're still in court. So you can spend 10 grand on a will. You can download somebody's free will program, and they're both going to end up in court.
Yep.
That it's a tool of court to have your wishes known in court. And so people need to understand that when attorneys are offering, a low cost will or a free will, or those programs that say, well, if you join our membership, then you get a free will.
Mm-hmm.
All they're really saying is, here's our calling card. We'll see you in 10 to 15 years to get $10,000 from you when you have to probate.
Right. There you go.
So, I mean, another cynical side of me, but I really want people to understand that you're not avoiding a problem with a will. You're adding clarity to the problem, but you're not avoiding it, because everyone has a will. If you don't have a will, the state has written one for you. And those are, I always say, raise your hand if you trust the government with your will. Like, nobody ever raises their hand. And that's good, because those are horrible situations. I had a case where the state in Utah, the intestate will says that if you pass away, the spouse gets the first $75,000,
Mm-hmm.
and then everything else is divided equally between the spouse and the surviving children, the heirs. Okay, sounds great, but what about, let's say that in Utah is a separate property state, and the house was in the dad's name. He passes away, so now mom doesn't have title to the house. It's a part of the estate. She gets the first $75,000 of the estate. But then, there's 4 kids. There's a 5th distribution to each child, and if they don't agree to keep mom in the house, she's evicted. Because they want their share. They got to sell.
Yep. Yeah, that's we had a situation yesterday. We had a guy call us, and he lived in another state, and his dad, he told us. My girl was on the phone with him for an hour, and he told us about all of the relationships that his dad had had over the years. He was in the career army and traveled the world and had a lot of fun around the world, let's say. And he had married a lady not long before he passed, and they had bought a house together, and they did it with joint tenants with survivorship, right? So cool, right? Most of the time they're tenants in common, and then you get in the situation like you said where it's like, oh crap. Now, but they died a few days apart, but we had to kind of explain to him, like, well, because he died first, 100% of the house went to her immediately because they were joint tenants with survivorship. So now this asset is owned by her, and he's like, well, can I get some of that house? I mean, that was dad's house or whatever, and I'm his only son. And I said, you have to get an attorney involved in this, because the way they did this title, it went to her. He's like, but he died a few days later. I said, well, but she still died first, and it just automatically went to him. And then now you've got to deal with her kids that you've never met in your life, So sorry, man.
A will would have a predeceasing clause. Sometimes state statutes do, if you die within 30 days of each other, then you're considered predeceasing, so we can skip multiple probates. So, maybe that applies in his state and his situation, but yeah.
Yeah.
And that's the problem we run into. This is kind of a different subject, but these probate avoiders, people well, I'll just write a beneficiary deed, or I'll just write a, name a beneficiary, or a title on death, or a pay on death. I'm like, that's great when it works, but what if they die in the same accident as you, and now there's a beneficiary deed to them in their name, and it has to be probated.
Right. You're still in probate either way, right? Yep.
So they're great when they work. They're horrible when they don't. So in estate planning, there's always a good, better, best, and I put those on the good level because there's some value to them, but at the same time, if the target's not there, there's nothing to hit.
Right. There you go. Exactly. Now, I'm sure you deal with this quite a bit. How does Utah and or Missouri handle if heirs are missing or estranged and you've got to file a probate? Is there like a kind of a notification period? Do you have to notify them for X amount of time? And if they don't come forward, or does the estate just sit in limbo forever? Like, how does that work? And
So as far as identified heirs, it's the estate's responsibility to notify everybody, but they don't not collect because they didn't show up. Like, I've had judges like, well, where's dad? Well, he's absent. We don't know where he is. We put it in the paper. Well, that's great. And so we're going to hold on to dad's share until he shows up or until it escheats to the state. Like, they're pretty sticklers about that.
Yeah. Okay. Yeah, we had one. I've had a few deals where, you have my sister's a drug addict and homeless, and we don't know where she is. We haven't seen her. We had one recently where during the process, they discovered that the brother had died. He'd been homeless for a while and was a drug addict, and then he actually died. And because they called the last homeless shelter it was at, and he died or whatever. And then turns out her brother had a daughter, and then now there's another layer to this pie, so it happens for sure.
Those are the sad intestate, stories where this unknown heir is all of a sudden taking, resources that you poured into, that maybe you were the caregiver for your mom and took care of her for 10 years, and the promise was that you'd get the house, and all of a sudden this unknown heir is like taking half of your hard work.
Yep. I had this brother and sister of a husband. This lady had gotten kind of remarried later in life. She had a daughter, and her husband's brother and sister, who had never been around ever, upon the death, he now had rights to this property, legal rights to this property, and the house was in foreclosure, and there wasn't much equity in it, right? But these brother and sister fought us over $1,500. And I told him, I was like, I will give you $1,500. Like, just if you hold this up for another 2 weeks, it's going to go into foreclosure and no one's getting anything. And that's what happened. She was going to get about $5,000 at the end of the day. The daughter was, right? And then at the end of the day, because these other heirs showed up, it's like they sabotaged the whole thing. Over $1,500 each.
That's the big risk of probate. We're leaving so much to, beholden to entities and agencies and then things that are outside of our control. And it's kind of, I joke, but not really. Like, this is the one area where the government got it right in giving us trust, because we got control back. We got, we're able to manage those things. And another pitfall of probate that a lot of people don't think of, that you made me just consider a minute ago, we're mobile. We're mobile people, like, Airbnb and all these things. So we go and, maybe I live in Utah, but I buy a little bungalow in California and I Airbnb it out. And when I pass away, now I have real estate in multiple states, and families don't understand or don't realize or haven't even thought about it, but they have to file a probate in each state that there's real estate, because the real estate is subject to the state law that it's located in.
Yep.
So now we're filing a $20,000 probate in California and a $5,000 probate in Utah, wherever there's real estate. And, that also is done away with a trust, because now there's no probate.
Yeah, the trust owns the real estate, not the person. Yep. Yeah, I love that. That's great. And you think that you'd be surprised, and I see it, right? As an investor, I get people that want to sell an investment from especially in the last few years. You mentioned Airbnb. Everybody and their brother wanted to do Airbnb, right? And I saw this market become so saturated in the last 2 years because everybody and their brother was doing it, and everyone on Facebook was selling you a course on how to be a short-term rental expert. And now all these people are realizing that it's not what it was cracked up to be, and they're starting to sell these houses. I'm surprised at how many I see that are like in their personal name and they don't even live in our state. And I'm like, I mean, at the minimum, you could have just set up an LLC here and put it in the LLC, but wow, that's a lot of risk. But
Yeah. And, when you talk to the real estate investor side of your audience, there's very, strategic ways to approach owning these properties, and, the estate plan that needs to be a part of it. It's not just about asset protection and diversity, but we need to make sure that if you die, that there's a plan in place that they're all going to go to the right place.
exactly. Yeah, definitely, for sure. You got to, put that in your operating agreements of your LLCs and that sort of stuff. I've got kind of verbiage that my attorney helped me kind of put in my operating agreements that helps my wife handle things and gives her certain powers and things if I pass, so that she can continue to run payroll and continue to, dissolve the assets of the LLC and that sort of stuff if she needs to. So
this is a really good time if you are an investor to review this with your attorney, because a lot of attorneys prior to this year, referencing the Corporate Transparency Act, a lot of attorneys prior to this year would write a current transfer, like, I transfer my company, my LLC, to my trust. It's a current transfer. And then they would say, just put that in the trust and don't file it until you need it. That was common practice.
Sure.
However, now there's this 2-year felony if you willfully or intentionally obfuscate the truth. And there could be an argument that that's what that is. So talk with your attorney, make sure that it's not doing that anymore, that you can actually just make it a future transfer, a title on death or a transfer on death, and file that in your trust. And so it's not any, willful or intentional obfuscation of truth. It's just a future transfer. But a lot of attorneys haven't made that shift yet because they don't have their fingers in business law and realize that if the trust owns the business, the trust has to now report, the people, the trustee and the beneficiary to this beneficial ownership information database.
Vincent. Yep. Yeah, that's coming soon. When is the deadline of that?
So it affects anyone that creates a business this year, and affects the rest of us, January 1.
Yeah, I've been getting emails about that and people talking about that. You've got to, despite trying to hide your beneficial interest, but the government's going to find out one way or another, right? And this is kind of their way of trying to get in.
Well, and it's just a bizarre law, and this really isn't the focus of the thing. But a lot of your investors run businesses, so it's worth talking about in the auspices of estate planning. It's a $500 a day fee up to $10,000 per entity, so it's kind of serious.
Sure.
And every time my clients hear about it, they call me like, "Is this a scam?" And the first time I heard about it, I thought it was a scam. So I'm like, "No, don't worry about it." But I did my due diligence. I looked into it. I'm like, "Oh, it is a scam. It's just run by the government." They don't have. I don't think they have the personnel to look over your shoulders on this one.
Not at all.
But if your head pops up on somebody's radar, this is the first thing they're going to check. Are you in compliance?
Yep.
And if you're not, they're going to cut your head off with it.
That's right. Yeah. So if someone is in the real estate space, an investor or whatever, and they're looking to get, and they're in the state of Utah or Missouri, and they're looking to get their estate planning in order, what advice would you give them to kind of get started with that? What's probably their first step if they want to do that?
That's a conversation. Reach out to me, reach out to another attorney. Do a financial statement of sorts so we know what we're working with. I prepare. I have a estate plan guide that I made that I send out to you, and it's going to give me all the information I want, so we can have a intelligent conversation about you and your situation, and then just understanding that you don't have to do it all at the same time. Like, that can be very onerous and very just overwhelming. Let's get the trust made. Then let's look at the LLCs and see how they're, made and how they're linked together. And that's LLC is another example of where the state made it so easy for us. We could just go online and file our LLC, and you actually don't have an LLC, or you're actually not following the rules of LLC. And when you get sued, you have no limited liability, and your personal assets are available to the lawsuit.
Right.
You've gone 15, 20 years with your LLC wrong in the first place. So let's get the trust down. Then let's start working on the LLCs and fill in what you're missing. Let's start connecting the dots that way. But you don't have to stress about it. Just kind of drop it all on the attorney's desk and say, what do we do first?
Yeah, and maybe let them know ahead of time. Hey, I wanted to take this in steps. What should we do today? And then maybe in 6 months, when I have another $1,000 or $3,000 or whatever to pay you, what would be the better approach? Or maybe you do a good, better, best in steps. So
yeah, and sometimes I offer a lot of bundling, for lack of a better word. Like, if we're going to do all this at the same time, there's a lot of work that overlaps. So I'm going to shave time off and money off. So you're going to save money. You're going to spend more up front, but it's going to be cost savings in the long run, because I don't have to revisit the case in 6 months and relearn you and pull everything back up. So there is some time and cost savings to doing it all together, but sometimes it's just not worth the mental gray cells. And so take it as you can take it.
Sure. What would you say? I mean, if someone, maybe they didn't have done any estate planning or whatever, they're a real estate investor, real estate professional, or any entrepreneur for that matter, like, I mean, at a bare minimum, what should they have in place to, like, step one, right? Like, what do you think where they should be?
So, get your jogging shoes on and run to your attorney's office. You want, a lot of people think that the cost of a trust depends on how much money we have, how much assets we're putting into it. It's really not the case. The cost of the trust is time specific on the avenues of our life that we need to work on. Are we married? Do we have minor children? Do we have children from different relationships? Are we running businesses? Are we investing in properties, which is running a business, but some people don't see it that way. Those are the complexities. Like, are we worried about what happens to the money when we die and our spouse is remaining? Do we want that locked down? Do we need that to be, bifurcated so that the children from the previous relationship don't feel like, the money hungry new wife is stealing their inheritance? Like, those are the questions that create the complexities, that lead to costs. And so, bare minimum, just a very simple trust based estate plan with a trust, or over will, power of attorney, healthcare directive, HIPAA waiver, and there's some different ancillary documents per state that you're gonna want in place, and that's the bare minimum.
Okay, cool. I like that. So, hey, Michael, you kind of run out of time today. I'm sure you got other things to do today, but I really appreciate you coming on. If someone in Utah or Missouri is interested in working with you, how's the best way for them to get in touch with you? I know you've got a great website. I've seen it. How can they get a hold of you?
And the website's the easiest. So www.legallifeplan.com. There's a button that just click on the button for a 20-minute Zoom. It is literally, there's no obligation to it, except I do want you to come prepared. There's a download, you fill that out, send it back. Don't put any information on that you don't feel comfortable sharing with me until you meet me. That's fine. But at least it's the beginning of a conversation. And so you can get on my Calendly link and Zoom and pretty much meet me from comfort of your own home and start having that conversation.
Awesome. Well, cool, man. Well, I appreciate you coming on today and sharing your knowledge and your expertise in Utah and Missouri both. It's not every day that you get someone who's licensed in two states that are separated. You get them like side by side, right? But like, you guys are a little bit separated there. So thanks for coming on today, man. And guys, like he said, you can go to his website and get a hold of him. Do you have any other like media, YouTube out there, or anything that you do that they could go check out?
I have a big Facebook presence. It's at Vehicle to Wealth. It's at Vehicle to Wealth on Instagram. LinkedIn. So at Vehicle to Wealth.
Okay, awesome. Well, hey, thanks for coming on, man. And guys, like I mentioned in some of the other episodes, if you're a real estate professional, agent, or investor, and you're interested in getting into the probate estate niche, I've been doing it for years. I'm an expert at it. I've been doing marketing in this space for a long time. We actually offer a done-for-you marketing package where we handle all of your marketing to get more leads, to buy more houses, and we're working on a training course to help you become an expert in the probate and estate niche. So if you're interested in learning more, you can go to probatehouseguy.com. Thanks for listening to the Probate House Guy podcast today, and stay tuned for next week's episode. Talk to you later.